So here's the thing, Mr. Johnson. If I give you an opportunity today, it's probably going to be the worst I could do today is give you 5 years in prison if I sent you to prison.
There you go.
All right. So are you Jonathan Richard?
Yes, ma'am.
This is cause number 25 DCCR 0248. Mr. Richard was charged previously with evading arrest or detention with previous convictions and was found not competent to stand trial and sent to the John Dunn Behavioral Science Center for competency restoration. Received the report from them dated May 4th of 2026. I'm going to take judicial notice of the court's file. The report states that Mr. Richard has not achieved competency, is not competent to stand trial at this time. There is a trial competency evaluation report, which was prepared by Dr. Turner. And that report is that he is not competent and that current competency restoration treatment would be necessary for competency restoration. In addition to that, there is a forensic psychiatry report from a Dr. Shahani, again, with the finding that he is not competent to stand trial at the present time. Also, there is a physician's certificate of medical examination for mental illness prepared by Dr. Shahani. It makes the finding that the patient is mentally ill, and as a result of that, they state that he does not meet the criteria for inpatient, but meets the criteria for outpatient treatment because the nature of the mental illness is severe and persistent. As a result of it, if not treated, would deteriorate. In addition to that, there is a second physician certificate of medical examination for mental illness from Dr. Select. That has the same finding that Mr. Richard is still not competent to stand trial and that outpatient treatment would be warranted for competency restoration. Any other evidence with regard to competency?
None.
At this stage, the discussion is no longer about whether the defendant needs treatment. It has shifted to what the court is legally able to do. Even when experts recommend a certain path, judges must work within the resources available in their jurisdiction. That practical limitation can significantly shape the outcome of a case.
Defense judge.
So obviously, we all know, and for the record, we do not have an outpatient competency restoration program here in Jefferson County, nor in jail competency restoration. And so I don't have any choice but to order inpatient treatment because we don't have that, unfortunately, here. So at this time, I am going to find, based on those reports, that Mr. Richard is still not competent to stand trial, that inpatient competency restoration placement is necessary because that is what we have in order. Mr. Richard, for a period of not to exceed 1 year to the appropriate facility for competency restoration. We obviously need to make sure, Ms. Malfino and Mr. Parker, that y'all take a look at the dates on this and how long he has already been in custody. Since it's a state jail felony, we're probably
Should expire while he's in.
So we need to check those dates. If you'll get that date, if you'll make a note so that we know we can get him back whenever that date hits.
Okay, I'll email.
All right. All right. You can go back with the bailiff.
You can judge.
Mr. Rojas, you've got Manuel Cardenas.
No, it was 12.
Okay. We're going to reset Sarah Jordan.
Jordan.
Mm-hmm.
And also, Judge, we're going to ask to reset Mr. Pugh, Willie Pugh.
Okay. What's up with that one?
Ashley was going to.
I just haven't been able to reach the officer yet, Judge. Sorry, it's just 1 week would be.
Yeah, we can be fine.
To ratify off of.
Good morning, sir. Are you Manuel Cardenas Jr.?
Yes.
This is 26 DCCR 0040. And Mr. Cardenas is charged with injury to a child, elderly, or disabled individual. And I'm going to take, okay, let me take judicial notice of the court's file. Mr. Cardenas was evaluated for competency to stand trial. And Dr. Grimsley prepared a report and evaluated him. I've received that report. It's dated April 8th of 2026 with the finding that Mr. Cardenas is competent to stand trial. Is there any other evidence with regard to competency?
No, Your Honor.
There.
All right, and will he waive the formal reading of the indictment?
He will, Your Honor.
All right, Mr. Cardenas, in cause number 26, DCCR 0040, you're charged with the third-degree felony offense of injury to an elderly individual from October 13th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you actually did what they've charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $1,000 fine. You would be required to follow all of the rules and conditions of probation, which would also include having no contact or communication with Manuel Cardenas Sr. Do you understand?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Cardenas is not competent?
No, Your Honor.
All right, Mr. Cardenas, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case so that we can make sure everything is covered that needs to be while you're on probation, and then we'll come back later for sentencing. And it looks like the state's you're opposed to a bond.
I am, Judge, just due to the nature of the case and the underlying need for that competency evaluation. I have not had an opportunity, or have not heard back from Mr. Cardenas Sr. And I would just prefer with that PSI to make sure if there's any APS orders, et cetera, in place, that we have a pretty strict no contact structure. Obviously, that's his father.
Sure.
So it's
All right, we'll see you back at sentencing. You can go back with the bailiff. Kelvin Johnson, Mr. Rojas, it's a sentencing.
Kelvin Johnson.
No.
Kelvin Johnson.
Good morning. Are you Kelvin Johnson?
Yes, ma'am.
And this is 25 DCCR 1781. Mr. Johnson was previously in court, entered a plea of guilty to the state jail felony offense of theft of property with previous convictions, entered pleas of true to prior convictions, making this a third-degree felony enhanced. The agreement was for a cap of 5 years in prison. I've received the pre-sentence report. Have you both had an opportunity to review that report?
We have, Your Honor.
Any additions or corrections?
Not from the defense.
Not from state.
All right, Mr. Rojas, you may.
Sentencing hearings often reveal details that never appear in the original charges. Instead of focusing only on the offense, the court begins examining the person's history, circumstances, and future prospects. Those factors don't erase accountability, but they can influence what the judge believes is the most appropriate sentence.
Proceed.
Thank you, Judge. Obviously, Judge, when you look at this PSI, what stands out is criminal history. It looks rather lengthy on paper. I'll point out to the court that most of the misdemeanors, anyway, are trespassing cases. And I would guess, and Mr. Johnson tells me this is a case that most of those, because he was homeless, didn't have any place to go. And as the court knows, if you're homeless and don't have any place to live, you're going to probably pick up some trespassing cases. He does have 2 prior cases which where he got probation and was revoked. I understand that's not a good track record when we're here asking for probation. I will point out that I think the most or the felony probation case was in 2000, and the one where he was revoked on the misdemeanor was in 2020. So a little bit of time has passed between those two. As far as this current case is concerned, if you look at his statements, he looks like he was stealing food and clothes, necessities. $72 worth, which would ordinarily be a misdemeanor, but for the fact that he already has his 2 prior theft cases, and the other felony case was bumped up to a 3rd degree. He's asking for probation, Judge. And again, the felony history anyway is from the last felony case is from 2003. It looks like 23 years ago. He tells me that prior to being arrested, he was working for a church, being paid on a daily basis. Also did some work for a car dealership out in Silsbee. He tells me he can go back to both of those jobs. The car dealer, he doesn't have transportation, but the car dealership came and picked him up and brought him back and forth to work. So that shouldn't be a problem as long as that job is still there. According to the PSI, he's going to be living with his mom. So we're asking the court to consider probation, a deferred probation term. If the court is not inclined to do probation, I would ask for the minimum term on this 2 years, given the fact that things he was stealing, necessities, and the length of time since his prior felony convictions.
Thank you, Mr. Rojas. Ms. Malfino?
Judge, I don't think he is necessarily not a candidate for probation. I think it should include safety. In my opinion, if the PSI reads as if he expressed interest in that, I would like to ask him if he really wants to take advantage of that. Otherwise, we're just going to be back here in a year on the same situation.
And I apologize. Mr. Johnson did want to speak to you, so whenever.
All right, go ahead, sir.
So the first charge I ever got, it was in 99. I did my time. I got out. I had a family. I lost it because me and my wife got into it where she took my kids to Louisiana. I not gave up, but I became homeless. I got all them trespasses. Then I started stealing food and clothes out the store. But being in the county for the months I've been in there, I see it was wrong. You know, one thing about me, I live and learn. But 2 things happened as I was doing what I was doing. I stole out the store and the police came up to me, which they didn't bring me to jail. He told me this one thing. He said, you didn't have to do this. They would have gave you the food. And then showed me instead of stealing, I could just ask. And then another time I was panhandling on College Street at the burrito place. And across the street was a car wash. And instead of me, and I looked and I thought about something. And I crossed the street and I started asking them to wash their cars. So what I'm getting at that is it's better to work than to be doing all that. You know, it's a different way that I'm going to go by doing things this time, you know.
How old are you?
45.
Yeah, time to start doing things
Yes,
different,
ma'am.
huh?
Yes, ma'am.
Anything else?
This is the moment where the hearing shifts from reviewing the past to deciding the future. The judge isn't simply announcing a punishment, she's weighing whether the defendant has earned one last chance under strict supervision. The next decision could determine whether rehabilitation replaces incarceration.
So here's the thing, Mr. Johnson. If I give you an opportunity today, it's probably going to be the worst I could do today is give you 5 years in prison if I sent you to prison.
Wow.
You'd be out in 2 or 3 years and that'd be it. If you really want to change your life and you want probation, it's going to be for a longer period of time. And if you violate, the sentence could be for a longer period of time.
Yes, ma'am.
It's going to require safety so that you can have the tools to be successful, to not turn to alcohol and drugs and things like that. So I'm going to kind of leave it to you. If you really want that opportunity, I want you to take it. I'll give it to you today based on you've been very upfront. Your history is all clearly because of homelessness and drugs. I mean, that's clear. So if you want to change, I'll give you that opportunity. Is that what you want?
Well, probation.
Mm-hmm.
Yes, ma'am.
Okay. So here's what I'm going to do, Mr. Johnson. I'm going to find that you entered your plea of guilty freely and voluntarily previously. Find sufficient evidence to find you guilty, and at this time find you guilty of theft of property with previous convictions. Find those prior convictions that you pled true to, true. Sentence you to a term of 10 years in the institutional division of the Texas Department of Corrections, but I'm going to suspend that. You'll be placed on probation for 10 years. You'll be ordered to follow all of the rules and conditions of probation.
Yes, ma'am.
That is going to include entering and successfully completing the SafeP program. So you'll go to the inpatient part of SafeP in custody, and then you'll get out, you'll have aftercare. All of that's going to help you find a place to live, get hopefully a job, stay clean, do everything you're supposed to.
Right.
If you do everything you're supposed to, then for all practical purposes, your case here in court's over. You'll be able to serve that 10-year sentence while you're out on probation. But the other side of it is if you violate your probation, I'm going to see all this history. I'm going to wonder why I gave you this opportunity, and you're going to end up with that 10 years that I just gave you. You understand?
Yes, ma'am.
All right, so I'm going to hand you the trial court certification that shows this was an agreement that I followed. So you have waived your right to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law.
Today's courtroom session showed how quickly a case can change, from bond revocations and drug testing to plea agreements and probation warnings. Judge Raquel West made one thing clear: respect the court, follow the rules, and take every condition seriously, because one mistake can completely change the outcome of a case.
Thanks for watching and subscribe my channel.